If a doctor caused you significant harm here in New York, and now you bring a lawsuit seeking compensation, and the doctor refuses to settle, but his insurance company wants to settle, what ultimately happens? Will they settle your case, or won't they settle your case? You want to learn the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. So now you believe a doctor caused you significant harm, that he violated the basic standards of medical care, causing you significant injury. Now you've decided to bring a lawsuit to get compensation for the pain, the suffering, and the injuries and the damages that you suffered because of his carelessness. But now, during the course of the lawsuit, you learn through your attorney that the doctor refuses to settle the case, but you also learn that his insurance company, his medical malpractice insurance company, wants to settle the case. Will your case settle? The answer is maybe yes and maybe no. It all depends upon whether the doctor has an insurance policy with something known as a consent clause. Now, what is that? A consent clause is when the doctor has the ability, has the power to tell the insurance company whether or not he agrees to settle a case or not during the litigation process. You see, many years ago, insurance companies wanted to give doctors the opportunity and the control to decide whether or not to go ahead and settle a case during the course of litigation. And in an effort to do that, to show that they were doctor-friendly, they put that into all of their insurance contracts. But what they didn't realize was that that was going to get them into a lot of trouble in a situation where they believed, the insurance company believed, that they had clear liability or that there was significant liability. And it was in their best interest to try and settle the case before it ever got to trial. So now in these conflicted cases where the doctor refuses for whatever reason to settle and the insurance company believes the case should be settled and can be settled, now you've got a clear dispute. So what happens then? If the doctor has that control in his insurance contract that says, yes, doctor, you have the authority to tell us, nope, you're not settling your case, then guess what? The insurance company has to abide by that. But if the doctor's insurance policy does not have this consent clause, now the insurance company has the ability and the authority to make the decision to go ahead and settle the case, even though the doctor does not want the case settled. So the insurance company will have to determine whether or not that phrase, that clause is in the insurance contract, and if it is, the doctor controls what happens as far as settlement. If it's not there, now the insurance company has the ability to go ahead and settle the case without the doctor's consent. So why do I share this quick information with you? I share it with you just to give you an inside, behind-the-scenes look at what goes on in these medical malpractice cases here in New York. You know, I realize you're watching this video because you probably have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need answers first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.